Hi, I'm Greg Dell, and I'm here with Victor Penna. And today we're going to discuss a recent case against the Aetna Disability Insurance Company. Now, Victor, I know you've handled numerous cases against Aetna, and this one in particular was not one that we hired. However, it brings up a common theme of potentials that call us or don't call us, and people try to do their own appeals and get their benefits denied, and they say, well, I don't understand. The disability insurance company decided not to pay me, but Social Security Administration is paying me. So why am I not getting paid by Aetna or my long-term disability insurance company if Social Security is? So talk about that and what the court said in this particular case that runs along the theme of what I just said.
Okay, and like you said, it's a pretty common theme. It happens a lot. This particular case was decided by the 11th Circuit Court of Appeals. They upheld a lower court, district court's decision that Aetna's decision was not wrong for denying the claimant's claim for disability benefits. So in this case, Mr. Oliver, he was a carrier for FedEx. He suffered a work injury, had to file a short-term disability claim, which was approved, and Aetna paid him 24 months of own occupation, occupational disability benefits. Shortly before the 24-month mark, he received a letter from Aetna notifying him that to continue to receive benefits beyond that 24-month mark, he would need to satisfy a new standard.
Now, is that common for a change of definition?
Very common a lot of times. Specifically in Aetna policies, sometimes you see it at 18 months, sometimes 24 months. Other carriers, you'll see it at 36 months, but it's very common that for the disability, definition of disability to change.
Okay.
So in this particular case, it was a very, very tough standard. According to the policy, we have to show that a complete inability to engage in any compensable employment for 25 hours a week, which is, it's kind of unusual. You see that change, but it's tougher than normal. So he applied. He submitted an application for the benefits beyond that 24-month mark. It was denied. His appeal was also denied. But around the same time of the denial, he received a letter from Social Security approving his claim for Social Security disability benefits. So, of course, he notified Aetna. Aetna was aware, and they actually referenced it in the appeal denial letter, essentially dismissing it, saying that Social Security Administration's decision does not determine their findings. So, of course, Mr. Oliver filed a lawsuit, district court, federal district court. They upheld Aetna's decision, saying it wasn't wrong, and the higher court, 11th Circuit, in reviewing the case, focused specifically on Mr. Oliver's argument, which focused on the differences in the interplay between Social Security and Aetna. So according to the 11th Circuit, a claimant can't rely solely on the fact that they're approved for Social Security benefits to show that an insurance company's decision is wrong. Here, they specifically pointed out the differences in the way disability is defined. So Social Security, much different standard. They have to show, or you have to show that you are unable to engage in any substantial activity. Whereas in the Aetna policy, of course, you had to show that a complete inability to engage in any compensable employment for 25 hours a week. Very different standard. Also, they pointed out the fact that the Aetna policy also contained a requirement that he show or provide significant objective findings of disability, which the Social Security Administration, of course, is not required.
And what was the disabling condition?
He had several conditions. First, he had a knee condition, had 3 surgeries, knee replacement, and also some degenerative disc disease in his back.
So it wasn't hard for this claimant, though, to meet the objective evidence threshold.
Right. So he had that, but the difference is that the point was in finding and his argument that they should rely on the Social Security's decision, they pointed out the differences in the policy. So the fact that there were so many significant differences made it harder for him to push that forward as additional evidence.
Right. So, I mean, this policy that we know very well is the FedEx policy that was offered through Aetna. It's a very restrictive policy. It's not the norm. Mm-hmm. Usually you find that when you get that 24-month change of definition, the Social Security definition of disability and the any occupation change of definition in the long-term disability policies are usually very similar.
Right.
And in those cases, I think that having an approval of Social Security disability would hold more weight than it did in this particular case. However, I guess it's really important to note that Aetna did review that Social Security opinion, because had they given it no weight, the outcome of this case might have been different, where the claimant might have been able to win or at least get a remand.
Right, and the court did point that out. The claimant actually referenced a case that they try to use as additional support, and the court said, yeah, you're right, Aetna can't just ignore it, the fact that you're approved for Social Security benefits, but they didn't in this case.
Right. Okay, so if you have a case with Aetna or any other disability insurance company, whether you're applying or you're having trouble managing the claim or you've been denied, you need to file an appeal or a lawsuit, feel free to call any of our lawyers. We can help you in any state throughout the country. We always offer a free consultation to let you know right away if we can help your file, and we welcome the opportunity to speak with you.